Chief Justice.
Sorry, there's some feedback.
Chief Justice, sorry.
Sorry.
I thought before the judge responds, because I'm going to be just following up on your question.
Oh, Commissioner Singh.
Yes.
Yeah.
Yeah, so then he can give one response to it.
Yes.
Because thank you, Chief Justice. Chief Justice, I'm quite confused, you know. I'm not a lawyer, but for me, it's just common sense. One cannot be a player and a referee at the same time. And in this case, as you quite rightly said, Chief Justice, the matter was the same. It was leave to appeal, and leave to appeal was refused where Judge Unterhalter sat in that matter. And when the matter came to the Constitutional Court, he sat in the matter without recusing himself. Now, one would think that that was wrong from a common sense point of view. And for me, it's not law, but it's just common sense that one has to recuse themselves if they've been part of an earlier decision. That's all I want to say on this matter. Thank you, Chief Justice.
Thank you. Just to go back to my question, I was saying, Judge Unterhalter.
Chief Justice.
Commissioner Malema.
Yes. I was in the same spirit saying, before he responds, perhaps I should also add something on that one, because he says the legal issues and expectations of the litigants are two different things. But my question would have been, as a follow-up, adding to what you asked, what is his appreciation of justice must not only be done, but must be seen to be done? You appear from a person who rejects your leave of appeal, you go to a higher court, and then he says the law is not clear about that. I sit on the same matter. What happens to the principle of justice being seen to be done? Will I see justice being done in the context of him sitting on this matter, rejecting the appeal, and then going to sit on a higher court to listen to the same matters? That's what I wanted to add to your question. Thanks.
Thank you. Commissioner no JSC, and then I've got Commissioner Fiber.
I just wanted to make a follow-up.
Who is speaking? Oh, virtual platform. I've recorded
Commissioner
you.
Malema.
Commissioner Malema, you want to follow up? Please go ahead.
Just a quick one. The question is not about what are the views of your colleagues if the matter was to repeat itself. What is your conscious view as we stand now, before you get canvassed by different colleagues if the matter was to repeat itself? We want to know where you stand now, not what you are going to do. Because before you go to the colleagues, you've got your own clear conscience position of wanting to participate or not wanting to participate, and being persuaded otherwise by colleagues. Having discussed this now and in the past, where do you stand now? Not what colleagues say when the matter arises in the future. That's what we want to understand. Thanks.
Well, I hope I've been very clear. My view as a matter of law is that it didn't give rise to a conflict of interest, but I'm aware of the fact, having thought about it quite carefully, that other judges and lawyers could take a different view, and that is why I would most certainly consult with my colleagues. And the fact is that in courts, that's precisely what collegiality requires, and I would listen to what they said, and if I was ultimately persuaded that my legal view is wrong, I would obviously change, but I would also be persuaded, as I've indicated, that if there's no need in the light of a disputed legal question to sit, I would pragmatically step aside.
Thank you. Commissioner.
And it struck me in the course of listening to you today on this point that one of the skills I enjoyed specifically was that you didn't give up on a point. And and you know, David, Justice Unterhalter, you know, the thing was that even when a point initially appeared hopeless, you argued it, and in the High Court, and you ultimately prevailed in the Constitutional Court. We asked for a record of the JSC deliberations in the High Court. The point was hopeless. Everybody said the point is hopeless. But, we won 11-0 at the Constitutional Court. But it just struck me now that actually you were playing the role of advocate, but today you are trying to get a job at the Supreme Court of Appeal as a judge. And maybe there is scope for concessions here and there because it's a different position that you're trying to get to. So in that spirit then, I just want to just remind the actual facts of what happened on the last occasion, because I've now gone through the actual transcript, and I think there has been a conflation of two things, not intentional. I think everyone is acting bona fide. What you considered was an error is that you were not factually aware that you had sat in the SCA when you sat in the Constitutional Court.
Correct.
That's what you said twice was an error. What you didn't concede was that it was a legal wrong. So today you've been arguing that it was not a legal wrong. But there's no problem in making the legal concession without, on the facts, going back. Because on the facts you said it was an error because I had not been aware. That is what today you are saying was a collective error. It's the lack of factual appreciation that you had sat in both. That is what fell through the cracks.
Indeed.
So in the light of that, because there's actually perfectly reconcilable factual premises here in terms of what you said then and what you said here. And I felt uncomfortable when Commissioner Dodova was saying, have you misled the forum, this body? That's why I actually went to see what did you say, which is different. I don't see exactly what the differences are. So I would just like to encourage you not to argue the point and for us to move on from the point. I think that the general view is that whether you are right or not, this is not going to be decided by the Constitutional Court. You are no longer advocate Unterhalter, you are Justice Unterhalter.
Yes, I thank you for that intervention.
Yes.
I accept entirely that I didn't appreciate at the time that I sat on the matter in the Constitutional Court that I had sat on it in the SCF. I just simply didn't recognize that that was the case, and I said so last time, and I say so again. And nobody else on the Constitutional Court recognized it either, and in that sense I say it was a collective failure. What the legal position is in circumstances where this does happen, because of the lack of appreciation of the fact that I had sat previously, is a disputed question of law, and I've had everything I could possibly want to say on that score.
I think it's enough to say it's a disputed question of law. I think what I wanted to resolve was the factual issue of what happened, and I think we are together there. Chief Justice, I do have a legal question to pose to the candidate.
Please go ahead.
Yes, thank you. The judgment you wrote, the minority judgment in Eskom.
Yes.
Yes. Would you regard that as a hard case in the Dawkinian sense, in the sense that there would have been two permissible outcomes? Because the way you've described it in your application is that the majority adopted the consequentialist approach.
Yes.
And you, by contrast, examined the substantive content of the right. And if the claim of the applicant couldn't be located in the substantive content of the right, the consequences, hard as they may be, and that's the hard case according to Ronald Dawkins, we had to live with those. Now, there is a lot to be said about the majority's approach in the context in which South Africa finds itself, and the anxiety in which the courts feel disempowered. Why should we not intervene when we can see so much suffering and so much misery, which we can resolve by a piece of paper? So I do want to just look at whether that judgment is a reflection of your philosophy and how you would approach similar hard cases in the future. Because on the one version, the Dawkinian approach is devoid of principle, or maybe not principle, maybe legal principle, but it's devoid of empathy. You know,
Yeah.
And that could be a point to be raised. But on the other hand, you say, well, in order for the law to keep its credibility, it has to reside ultimately on legal principle. And that's where Dawkins actually is important as a teacher. So is that a reflection of your philosophy? And one of the things I don't understand with is why you had to go through all of that. It's hundreds of pages, but it was an interim interdict application. So I wonder whether if we had a full application on disputed clear rights issues, whether or maybe your perspective would have changed in that case, or because maybe that's what should have happened. Instead of the matter being decided on very difficult philosophical questions of law on an interim basis, it should have simply been left to the final judgment.
Yes, well, I'm glad that the Eskom case has come up, because I think of all the cases that I've written about, that was the case that is a truly, truly hard case. And it's a truly hard case because the reduction in the supply of electricity to that community was giving rise to very, very considerable hardship and indeed probably immiseration of people who are very vulnerable. So it's incredibly difficult when you get a case of that kind to say, well, surely that's the moment to just intervene and provide a remedy, perhaps an interim remedy, to try and alleviate the immediate harm. And that's why it's a hard case. And the majority of the Constitutional Court said, in effect, we look at the harm and we determine the rights by reference to the harm. Now, I think, and 3 other justices of the court agreed with me on this point, which is this, that, and there are 2, I think, points, and the one is a point really around the division of powers. Too often, the courts are being asked to resolve problems that under our constitutional order are actually the constitutional responsibility of other organs of state. And in this case, what is highlighted is that it's the municipality, as the Constitutional Court has previously held, that has the responsibility for dealing with those very conditions. And the risk of displacement, which is to say, courts should decide and resolve every hard consequence of what happens through various species of government failure, is a temptation that I think one needs to be very, very careful about. So I'd firstly raise the question around separation of powers. But the second, and maybe this does reflect my judicial philosophy, is this, that the key feature of our Bill of Rights is that one has to understand what they say, what their content is, because it's so important to the work that those rights have got to do, and what they do not say. And one has to work out what is a litigant claiming and what is a litigant not claiming. And it seemed to me, and it seemed to those who agreed with me, that that is the correct starting point as lawyers. And what courts must do is not simply say, I have to intervene because the consequences are harsh, unless the test involves a consideration of consequences. I must start with where is the right. And if that's considered to be too lawyerly a view, I don't think it is, because the liberating aspects of our Constitution must both begin with an understanding of what the rights are about, but they must also appreciate what courts can do and what they can't do. And that's, I suppose, why the Eskom case is important and why it is somewhat reflective of my philosophy.
Just one more point, Chief Justice. I get your point that, you've got to look at the text first and try and locate the right in the text. Now that I see, but I wonder whether, because when you look at the majority, it's sort of derivative, right? It's not direct, there's no right to electricity, right? But electricity implicates a number of other rights, right? Dignity, health, education, etc. And so what they do is a derivative exercise. And I wonder whether, in fact, there is a distinction in the approach, right? In principle versus consequentialism, in the approach of the minority and majority. And I wonder whether we needed this in an interim interdict application or whether it should have just been kicked for later.
It may well have been the pragmatic answer to say, let's all come back against the fuller facts and resolve these ultimate questions of right. But it did seem that an answer needed to be given because it has had systemic consequences for the country as a whole. If, as the majority found, the municipality in this instance was permitted simply to avoid its constitutional duty, and Eskom would be required to supply irrespective of whether there were any rights to assert, it has a massive impact both upon Eskom and about what happens across the country. So I think that was part of what went into the consideration of this as an interim interdict. As to the question of the derivative right, I agree that it's a significant part of how to think about this problem. But the difficulty I had with that notion was this, that particularly when one is talking about positive rights, as we know, they feature in the Bill of Rights on the basis of what is reasonably required of the state. And so to dictate the means is seemingly a preemption of what the state is given the liberty to determine for itself. And I thought that that was problematic in at least the derivative components of the case that were raised.
Thank you. That was the last